Hi, good morning. This is Rajeshkumar. Today we are going to discuss one problem question on frustration as well as related theory question. The video content has been made available for informational and educational purpose only. Kindly go through the disclaimer. Let's start with the problem question. First, we'll start with the theory question here. Mere increase in the cost will never constitute frustration. We have to discuss this theory. And the problem question is Fiona, a famous business woman, contracts with Grod PLC to give a speech at their annual dinner for a fee of £10,000, half of it payable on contracting and the other half on the day of the speech. Fiona also asked for a case of Krug champagne, which Grot agreed to send to her the week before the event. The venue for the dinner fails its safety inspection the day before the dinner is due to take place. Grot PLC made the first payment of £5,000 to Fiona but forgot to send the champagne. Later, they refused to pay the second installments or to send the champagne. Grot have ordered £1,000 worth of flowers for the tables which they cannot avoid paying for. We have to advise Grot as to their rights and liabilities. First, we will analyze the theory. The doctrine of frustration allows for a contract to be discharged when an unforeseen event occurs that renders contractual obligation impossible or radically different from what was agreed upon. However, the courts have been strict about what constitutes a frustrating event, particularly when the event relates to financial difficulties or an increase in cost. The general principle of frustration is the frustration occurs when, after the contract has been formed, an unforeseen event makes the performance of the contract either impossible, illegal, or radically different from what was initially contemplated by the parties. The leading case on the frustration is Davis Contract Limited versus Farham UDC in 1956, where a contractor claimed that the contract was frustrated due to unforeseen delays and increased the cost. The court rejected the claim, holding that the contract was not frustrated because the change in circumstances did not fundamentally alter the nature of the obligation. So the House of Lords stated that frustration only applies when a contract becomes impossible to perform or is fundamentally different, not merely more onerous or expensive. The doctrine of frustration applies when an unforeseen event occurs, fundamentally altering the contract's nature, so that it would be unjust to hold the parties to their obligations. For frustration to apply, the performance must have been become radically different, not merely more costly or difficult. The case Davis Contracts Limited versus Fraham UDC in 1956 is a seminal case here. The House of Lords emphasized that an increase in cost or inconvenience, however significant, it does not generally meet the threshold for frustration. The contractor in Davis argued that higher the cost constituted the frustration, but the court rejected this, ruling that commercial hardship alone does not suffice for frustration. The court have been made clear that a mere increase in cost will generally not constitute frustration. This principle is rooted in the assumption that parties should anticipate the possibility of cost increase and the price fluctuations, particularly in long-term contracts. If the contracts could be discharged whenever performance became more expensive, the stability of commercial transaction would be undermined. In Noble Thal GmbH case in 1962, a contract for the sale of the good was not frustrated even though the usual shipping route through the Suez Canal was closed, making the journey longer and more expensive. The House of Lords held that alternative route was still available, and although it was more costly, the contract could still be performed. In other words, moreover, in the Noblet Hall GmbH case in 1962, the court held that increased cost due to the closure of Suez Canal did not frustrate a contract for groundnuts delivery. Even though the closure required a longer and more costly route, the contract was not frustrated as it could still be performed in a similar way, even if less profitably. This case, among other Swiss cases, reinforces that frustration will not apply merely due to the increased cost, emphasizing that frustration requires a fundamental change rather than a mere economic one. In the Nemo case in 1982, Lord Roskill further solidified this principle, stating that economic adversity, such as loss of profit or the increased cost, does not equate to frustration. Only if the contract purpose is rendered completely unachievable by external factors will frustration apply. Similarly, in Davis contracts, the House of Lords affirmed the difficulties, delays, or increased costs alone do not frustrate a contract unless they fundamentally change the nature of the contract. In the event, only makes performance more expensive or less profitable. It is not sufficient to discharge the contract through frustration. There are some exceptions, the extreme cases of cost increase. Although a mere increase in the cost generally does not lead to a frustration, there may be exceptional circumstances where the cost increase is so extreme that it fundamentally alters the nature of the contract. In Denny, March and Dickinson Limited versus James B. Fraser and Co. Limited in 1944, the court suggested that frustration might apply in extreme cases where performance becomes radically different. However, this is rarely applied in cases of financial hardship or the increased cost. Let's conclude the theory question. A mere increase in cost does not constitute frustration under the English law as shown in Davis, Taslow, and the Nemo case. The frustration requires a fundamental change in the nature of the performance, not just an increase in the financial burden or reduction in profitability. In other words, the statement that a mere increase in cost will never constitute frustration is largely supported by case law. Davis Contractor versus Tasker Glove both affirmed that frustration is not available simply because performance become more expensive or difficult. The court have maintained that only radical change in the nature of the contractual obligations rather than increased financial burden will trigger the frustration. Let's start analyzing the problem question. Fiona, a famous businesswoman, contracted the Broad PLC to give a speech of £10,000. Has the contract been frustrated in this case? The first issue is whether the cancellation of the event due to the venue's failure to pass a safety inspection constitute a frustrating event. The closure of venue due to the failed safety inspection is likely a frustrating event because it makes the performance of the contract impossible. Similar reasoning was applied in Gamagos ACA versus ICM Fair Warning Agency Limited in 1995, where a concert could not go ahead because the venue was deemed unsafe. The court held that the contract was frustrated as it became impossible to perform the contractual obligations through no fault of either party. Given that the dinner cannot take place, the contract between Fiona and Grab PLC is frustrated, discharging both parties from their obligations. In other words, the safety failure leading to a dinner cancellation is likely a frustrating event. In Gamago versus ICM Fair Warning Agency Limited 1995, the cancellation of Guns N' Roses concert due to the venue safety issues was held to be frustrating event. as it prevented the parties from fulfilling the contract purpose. Similarly, here, the inability to host the dinner fundamentally changes the purpose of the contract between Fiona and the Grad PLC, rendering it unfeasible. The law reform, the Frustrated Contracts Act 1943, LRFCA, addresses the consequence of the frustration, particularly under Section 1.2 and Section 1.3, which allows for financial adjustments between the parties. Under the Section 1.2, any payment already made can be reclaimed unless the party has incurred expenses that justify retaining the parts of the fund. Therefore, the Grant PLC would likely be entitled to recover the initial £5,000 paid to Fiona, as the event was cancelled for reasons beyond their control. Fiona, on the other hand, cannot claim the second payment as the contract cannot be completed. In other words, LRFCA governs the consequences of frustration. Section 1.2 of the Act deals with money paid before the frustrating event and provides that any money paid before the frustration, here the initial £5,000 paid to Fiona, can be recovered. Any money that was due to be paid after the frustrating event, the remaining £5,000, does not need to be paid. This means that Broad PLC is not liable to pay the remaining £5,000 to Fiona. However, Fiona may be entitled to retain the initial £5,000 subject to court discretion regarding the expenses incurred by Broad PLC under the section 1.2. The flower cost, the £1,000 cost. Under the section 1 to the court can allow the party who incurred expenses grant to retain the part of the money already paid, the £5,000 to cover the expenses such as the flowers, which they ordered and cannot cancel. This provision was applied in Gamago, where the court ordered the return of the money paid in advance, but also allowed a claim for the expenses incurred by the other party. In other words, the order of flowers at the £1,000 constitute an expense that Broad PLC incurred due to the anticipated event. Under the Section 1.2 of LRFCA, the court may allow Broad PLC to recover reasonable expenses incurred due to the frustrating event. In Gmago versus ICM, the court permitted the recovery of certain expenses following the frustration. Similarly, the Broad PLC could seek to recover some or all of the flower costs from Fiona as an incurred expenses, provided they are reasonably and attributable to the contract frustration. What is the consequence of failure to send the campaign? Grot PLC failure to deliver champagne might be a breach of contract. However, this breach may be rendered moot by the event's cancellation. Given that the contract's primary purpose has been frustrated, any ancillary obligations, such as providing champagne, may be nullified by the frustration of the main contract. In other words, Fiona requested a case of champagne, which Grot agreed to send the week before the event. Since God failed to send the champagne, this is a separation issue of non performance. Under the frustration doctrine, God would no longer be liable to deliver the champagne because the contract is discharged by frustration. However, the failure to send it before the frustrating event could give Fiona a right to claim damages for breach of his obligation, but the frustration of the contract may extinguish such claims. To conclude, the venue's failure likely frustrated the contract between Grot PLC and Fiona, entitling Grot to reclaim the £5,000 initial payment and relieving them of the duty to pay the remaining 5,000. Additionally, Grot's obligation to send champagne may be excused by the frustration, and they may be able to reclaim expenses for the flowers ordered for the cancelled event. In other words, the contract is likely frustrated due to venue's closure, meaning Grot is discharged from their obligation to pay the remaining £5,000, and Fiona cannot demand it. The expenses. Under the section 1(2) of LRFCA, a Grod may be able to recover the £5,000 paid in advance, though Fiona could argue that a part of it should be retained to cover her expenses. Grod may be allowed to recover the cost of the flowers. Champagne. A Grod's failure to send the champagne before the frustration occurred could lead to breach a claim, but the frustration of the main contract might affect this. Overall, the contract between Fan and the Grot is discharged by frustration, and their liabilities are governed by the Law Reform Frustrated Contract Act 1943. Thank you.